Good afternoon. It's a real pleasure to be here with all of you, and particularly Kevin Smith, who is on this call with me because he was on our 12th annual panel of the long arm of the law at the Charleston conference last Friday, one of our two distinguished speakers. And we tend to like to interview those people and hear more from them. I know people want to hear more from Kevin. So I thought we would start by asking Kevin to tell us, a little bit more about himself, a lawyer and a librarian. How did that happen? Does it make sense? Does it work? Say more, please.
Well, thank you, Ann. I'm pleased to be here and happy to tell you a little bit about why I think it makes sense to be a lawyer and a librarian. I should start by saying I've been a librarian for 30 years and I'm the child of a librarian. So that makes perfectly good sense. But from the time that I was in library school, actually, I became fascinated with the idea of intellectual property. And in the first 10 years or so that I was practicing as a librarian, I tried to learn as much as I could about copyright law. And there was a point where the workshops and that sort of thing began to be repetitive. And I still wanted to learn more. And I was in a situation where I was fortunate enough that I could go to law school part-time while I continued to work in a library. So that's what I did, and I got my law degree. I've never practiced law and never planned to. I had always intended to be better at being a librarian. And I've had some wonderful opportunities thanks to that decision. And I've also, over the 15 years or so since then, observed the ranks of lawyer librarians and librarians who specialize in copyright law growing all the time. I think we all know that the impact of the law, especially copyright law, but also contract law, constitutional law in libraries has been growing almost daily. So I think the kind of specialty that I sort of stumbled into is really important for libraries.
Yeah, no, I agree, Kevin. And from what I've known of you over the years, you have used that double expertise really well on behalf of us all. So thank you very much for not just for the talk on Friday, but all the rest of it.
Well, you're very kind. Thank you.
Yeah. So, I mean, the other way in which I know you is that a couple of times I've invited you to speak at different events. And in a perhaps not entirely comfortable way, I picked topics and I've said, Kevin, this is really important. Can you talk about it, please? And you have always been very generous in saying yes. And you have a way of doing your research and bringing clarity to a topic, as you did last Friday when we talked about the new legislation in Maryland and also New York that is going to maybe affect the way in which ebooks are licensed to libraries. Can you just quickly describe the main points of those laws for people who may not have heard the talk on Friday?
Sure. And by the way, thank you for that invitation, Ann, because I got to learn something I didn't know a lot about. So it was good for me, and I hope the talk was clear to those who were listening. The legislation in Maryland, which has been passed and signed by the governor, will take effect on the 1st of January. And what it basically says is that any vendor who licenses, they call it electronic literary products, but we would probably say ebooks. Any vendor who licenses ebooks in the state has to offer a license to public libraries on reasonable terms. The problem it's trying to solve is the fact that some large vendors of ebooks would refuse to license ebooks to libraries. And, libraries have advocated for years now to have access to ebooks the same way they do physical books. And this law is an attempt to address that problem. I want to add, because it was raised in the chat during the talk at Charleston, that a huge problem here is that the concept of first sale, the doctrine that says that once you buy a copy of a particular work of intellectual property, you can distribute it any way you want. You can lend it, you can resell it, you can rent it, you can do all kinds of things. That doctrine, which is fundamentally what allows library lending, doesn't apply in the United States to digital works. Our courts have said that when you lend a digital work, you always are making a copy. But the doctrine of first sale is only an exception to the right to distribute the copy that you have lawfully purchased. And the courts have said for that reason, the fact that digital always makes another copy, the courts have said that first sale doesn't apply. So we can't go out on the ordinary consumer market and buy an ebook the way we would buy a physical book and lend it. We have to go through this licensing procedure. Publishers were unwilling to do that because they think that too many people will borrow a single copy of a work. And these laws are intended to provide some equity, if you will, in the way libraries obtain and lend materials in different formats.
It's pretty amazing to me that this isn't a question, it's a comment, that some library group or another got enough attention with enough legislators to get this into the legislatures.
Mm-hmm.
I mean, I don't know how they did that. And I don't know if your research told you who were the movers and shakers in that, but it's very impressive.
It really didn't. All I can say is I know there's been organizing around this topic for quite a while. I was, in fact, the representative of the ARL to a joint committee organized by the ALA on precisely this problem, on the issue of digital content and how libraries obtain and lend digital content. So I know there's been a lot of activity around that. It was mentioned during the talk. The group called Library Futures, which is an advocacy group that is focused on equitable right to knowledge as technologies change. So I know there are a number of groups out there working on this problem. And I think you're right. It's remarkable that they were successful in getting the attention of legislators in Maryland and New York. And I did say during the talk, a similar law has passed the legislature in New York, but it has yet to be signed by the governor.
Yeah, I mean, not to belabor the point of how impressed I am with the ability to get this to a legislature, but when I think about the IFLA work at WIPO,
Mm-hmm.
and the many years it took Winston Tabb and his team to push through the Marrakesh Treaty, which almost seems like a no-brainer. That was a valiant effort. We had Winston one year talk about that at Long Arm of the Law, but you really have to applaud librarians who have that kind of ability.
And of course, getting something through WIPO, which is an international organization with representatives from I don't know how many countries, is an even more complex process than getting something through the Maryland State Legislature.
Indeed. Now, this is happening in the laws of a couple of states, not at the federal level. Can you talk about that a little bit? You did the other day. Why is this happening at the state and not the federal level?
Right. I'm not sure I can say exactly why. Of course, similar laws could be introduced at the federal level. They would face perhaps a heavier opposition than this probably did in the state legislators. So one reason it may be happening at the state level is because it can get through the legislatures. But states clearly have the right to regulate intrastate commerce. There is an interstate commerce clause in the Constitution that says the federal government, Congress, has the right to regulate commerce between the states. But it's clear, and every state has adopted its own commercial code to regulate commercial transactions within their borders. So it seems to me, very embarrassing when your phone rings during an interview. it seems to me that it's perfectly appropriate for this to happen on the state level. It applies to the public libraries in Maryland and the vendors doing business in Maryland. A national law would have to be adopted by Congress under the Interstate Commerce Clause, but there's not a contradiction between the two, in my opinion.
Well, this goes back to a topic that you raised as well, which is that at least certain parts of the publishing community who are not fond of this legislation assert that it in fact is contrary to copyright law. Now, what's their argument and what do you make of that?
Right. Different from the authority under which a legislature would act, which is what I was just talking about, there is the issue that the copyright law explicitly says that it preempts any state efforts to legislate equivalent rights to those that are granted under copyright law. And I think the biggest challenge to these kinds of laws would be that they're preempted by Section 301 of the copyright law, which is what I just described, because they legislate the distribution of intellectual property. And the copyright law, of course, one of the exclusive rights granted by the copyright law is to distribute a work. So I think that's the strongest argument against the legality of what the Maryland legislature has done. However, the Copyright Office itself did a study and concluded that they did not believe that these state laws would be directly preempted because they were dealing with equivalent rights. They decided that the language of the Maryland law is not preempted by the grant of the distribution right in the U.S. copyright law. So that's a fine point that courts would have to rule on, but the Copyright Office itself doesn't think there is direct preemption here.
Okay. To be continued, I guess.
Oh, certainly.
Will be continued. One of the things you said about 5 minutes ago was that libraries can do certain things like lend and preserve and so forth because they're libraries and they have certain standing in the copyright law. The copyright law says that these have to be public libraries, which we understand, I've understood, correctly or not, as libraries that are open to the public. So what does public library mean, do you think, in these cases?
Yeah, it's a great question. And I think your understanding of what a public library is correct in the context of the copyright law. For the purpose of Section 108 in the copyright law, the statute actually defines what libraries are eligible to use that exception, which is what permits preservation copying and copying for interlibrary loan. And it uses that definition. A library has to be open to the public on some basis, even if it's a specialized library that only allows the public in by appointment, that would be good enough. That definition in the copyright law is extremely broad to really only exclude commercial libraries. But I think the Maryland legislation is directed at what we generally think of as public libraries, community libraries. So I think there's a different definition at work here. To me, there are three things that define a public library in the sense that we distinguish academic, school, and public libraries. A public library is usually established by local or state law or enabling regulations. It admits the public without restriction, pretty much, and it's usually supported by tax dollars. So, for example, I'm the Dean of Libraries at a public university, but my library would probably not be considered a public library if you look at those three factors. For one thing, although we get some state money makes up only about 18% of the budget of the University of Kansas. A much larger percentage is provided by tuition. And we have some restrictions on who can come in and who can have a borrowing card. So I don't think we would fall into that more technical or specific definition of a public library that I think is at work in the Maryland legislation. But I will add, the Maryland legislation doesn't define a public library. So if there is ever a court challenge to one of these laws, I think that will be one of the issues that's raised, along with the preemption issue that we just discussed.
Yeah, I mean, this question came up from the audience, remember, from a librarian at the University of Florida who said that her library is open to the public, and it may be under less restrictive terms than, let's say, yours is. But
it may not be either. I don't think that's all that goes into defining what a public library is in the sense that it's used in the Maryland bill.
Yeah. What I had not thought of before we organized that long arm of the law session on Friday and invited you and Leila Bailey from the Internet Archive to talk about that litigation was there are some similarities between the two situations. Can you? Well, no, I won't go on about that. I'll let you comment if you think that is in fact the case. I started to see some connections that I hadn't seen before.
Well, I think you're right. I mean, there are some. Of course, one is simply who gets to control the distribution of especially digital format works,
Right.
Which right now it poses or is perceived to propose a major threat to some of the large content providers. So there's that similarity. The Internet Archive is, and you heard it during Leila Bailey's talk, is very committed to the idea that it is a library. And the plaintiffs in that lawsuit have denied that. So there's a sense in which this definition of a library is part of the similarity between the two cases. You know, our law really favors libraries. It is structured in a way that is supposed to make the mission of libraries easier, because of course the mission of libraries is close to the heart of the purpose of copyright law. Copyright law in the United States is authorized by the Constitution in order to promote the progress of science and the useful arts. So that's the purpose of the law. It's the only enabling clause in the Constitution that has a purpose specified. So we need to take that seriously. And one of the ways Congress has taken it seriously is by building in sort of special provisions and a lot of room for libraries. So it's, you know, it makes a difference whether you're considered a library or not. In the case of the Internet Archive lawsuit, the Internet Archive wants to argue that they are fulfilling exactly the same mission as other public libraries do. And for that reason, they should get the benefit of a lot of those provisions in the law.
Yeah, and we'll have a chance to talk with Leila Bailey like this in a couple of days. And it is going to be one of the questions that's asked of her. Now, I know the Internet Archive is very adamant in defining itself as a library. It is, in fact, open to anybody who cares to use it. You know, those kind of democratic principles, I think, govern it. But I think their whole case may rise and fall.
I'm not convinced that it will.
No,
I'm not convinced that it will, actually. I don't think that's going to be where the real fight is. I should say, just as a matter of full disclosure, that I'm involved with a number of colleagues in working on a brief in support of the Internet Archive. So I should say that to indicate that I am not neutral in this discussion. But I'm not convinced that whether or not Internet Archive is a library will have that great an impact, because I believe the issue is going to turn on fair use, and fair use is available or not to anybody on the same terms. So the one place is that, you know, libraries get a little bit of a benefit in the fair use analysis because of that public purpose. And so that might make a little bit of difference, but I don't think that the case will rise or fall on whether or not Internet Archive is a library.
Okay, you heard it here from Kevin Smith.
It's been wrong before, and Leela may contradict me, and I'd listen to her if I were you.
Yeah, no, she's another force of nature, isn't she?
She is.
Pretty amazing. So changing gears a little bit, you're also director of the KU Press, or sorry, University of Kansas Press. Can I call it KU? Can we do that?
It's really important that you don't.
Okay.
The University Press of Kansas serves all 6 of the Regents universities in Kansas. So even though our offices are on the campus of the University of Kansas, and as I happen to be the director and also the dean of libraries, we being the press, is not an entity solely of the University of Kansas. We really report to the Board of Regents in Kansas.
Good to know. So there you are, director of the University of Kansas Press with all of its multiple arms and legs and whatever. Do you find any inherent conflicts between your role as an advocate for libraries and information and I'm presuming the need of the University of Kansas Press to make money, to license, whatever? Are there inherent conflicts or aren't there? And if there are, how do you think about them?
Sometimes there are. Certainly in my more strident advocacy, I have made statements about publishers that I wish had been more nuanced. University presses are very different than large commercial publishers. One of the things I've learned since I became the director of the University Press of Kansas is just how dedicated its staff is to the mission of making scholarship as available as possible, which doesn't actually obviously contradict the values that I've had for years when I was doing scholarly communications work. So I think it's really important to recognize that university presses are different from a lot of other kinds of publishers. They need to make money. And I became the director here partly to help the press address some significant financial difficulties. So I'm very aware of the need to make money, but I'm also aware that at university presses especially, the need to make money is strictly to drive the mission. And I'm very proud to help the University Press of Kansas staff pursue that mission.
So you think that you've actually been successful in reconciling the need to make money and the need to share information as widely as possible?
I hope so. I will say that one of my colleagues, the director of another university press, I won't name him, frequently says that presses are just trying to lose money in the traditional way. It's not lose money in big chunks, just in the traditional way. No university press manages without support from a parent institution. It's just not right now a high profit business. But yeah, we do need to make money to keep the lights on and to keep doing what we do well.
And it can be done. You heard it here again from.
I hope so. I've only been in this role since January. So, oh yes, this was new to me this year. So we'll see whether it can be done. So far, so good.
Because you've been at the university now for a few years, right?
That's correct. I've been at KU for 5.5 years. Okay. But the financial difficulties and the resignation of the previous director of the press led the Board of Trustees. The trustees of the University Press of Kansas are the 6 provosts of the Regents universities. It's really interesting to work for 6 provosts, by the way. But it led the Board of Trustees to ask me if I'd take on this role. So only in January.
Well, I didn't realize that. All right. Well, congratulations and, good luck.
Thank you.
Best of success, I think, not good luck. It's not, these things are often not a matter of luck, There's something much more than luck.
I think there is.
So going back to New York, Maryland, maybe, no, we'll skip Internet Archive for now. What do you think will, what's a scenario you imagine might take place in Maryland as this legislation becomes law on the 1st of January? Is it going to be ugly? Is it going to be smooth sailing? Will there be litigation? What's the best possible case? What's the worst possible case?
I think, and I tried to say this a little bit on Friday, I think there's a risk on both sides. I think the publishers, the Association of American Publishers, has issued a strong statement against this law, but I think there would be risks in litigating against it. Because you would have to defend what I consider an indefensible policy, which is the refusal to sell ebooks and I should say the concerted refusal to sell ebooks, license ebooks to public libraries. In this age when we're seeing increased scrutiny under antitrust laws of high-tech companies, I think it's risky for the major publishers and the publishing organizations to bring too much attention to that concerted decision to not sell or license ebooks to libraries. So I think there's some risk there. I think we may see the law just simply take effect and some grumbling, but that most publishers will simply adapt themselves to it. They'll find a pricing model that is reasonable. I mean, obviously, libraries will pay more than individuals do for ebooks, but they'll find a reasonable pricing model and figure out how to go forward. In other words, I think that we'll see cooler heads prevail in spite of the saber rattling that we've seen.
Well, it would be good if this legislation could become a kind of, I don't know what it is, a kind of point of conciliation and moving forward, rather than something that's even more divisive and wastes a lot of time. I don't mean that lawyers shouldn't be paid, but wastes a lot of years pass, and we get stuck. I
think most lawyers would tell you that we would live in a better world if there were fewer lawyers needed. But yeah.
I've had the benefit of having good lawyers in my life, so I appreciate those anyway. Tell me, so you were in a very specific role at Duke. You were the copyright, scholarly communications librarian there. And in a way, you were, one of the leaders who kind of paved the way for that role in higher education libraries. How is this different?
Well, first, thank you for that, because I'm proud of the degree to which I helped pave that road.
Absolutely.
So I appreciate your noting that. Of course, being the Dean of Libraries is very different for me in a lot of ways. I didn't have basically an administrative role when I was at Duke, although I had been the director of a small liberal arts college before I went to Duke. So there was a pretty steep learning curve for me. I spend a lot more of my time dealing with budgets and with efforts to maintain humane and equitable workplace conditions for my faculty and staff. I had never before been at a library where librarians are tenure track faculty as they are at Kansas. So there were a lot of changes, but that's been fun, and that's kept me invigorated and coming to work every day, because there's a new challenge every day. One thing I should say, though, is that when I came to Kansas, I knew that they had stellar scholarly communications librarians on their faculty and staff. I wasn't wrong, they do. And it's been a lot of fun to facilitate their work. Instead of having to be sort of the driver of it, and to use my position whenever I can to try to amplify the message that those really fine scholarly communications librarians are trying to deliver to the campus and beyond.
Well, I was going to ask you if when you got there, you hired one of you to work there, but it sounds like you already had them.
Well, yes, and the two people who are in what we call the David Schulenberger Office of Scholarly Communications and Copyright, Ada Emmett and Josh Bolek, were already here when I got here. They're great at what they do. So, I've tried to help support them and learn from them, but no, I haven't had to go out and hire me, and it would be weird if I did. I
So,
should say, though, if I may, I do want to add that one of the reasons that I decided to go into administrative work, of course, I knew my predecessor at KU, Lorraine Heracombe. I knew her and I knew the work she had done here. So I knew what I was getting into and I knew there was a solid foundation. But I had come to believe that the real progress that we're going to make in scholarly communications has to be driven from the highest levels of administration. So I decided intentionally to take an administrative role, a role where I was meeting weekly with the provost and the deans and able to deliver that same message in a different context.
wonderful. I assumed that you had actually applied for the job, not that you've been forced to join the university in this other role. Yeah.
Yeah.
But that's interesting. Your reasoning is very interesting to hear, and I've heard other people speak the same way. So I think we have reached just about the end of our time together here. I want to thank you for everything you've done for the profession. I want you to thank you especially because it's in this context for your service to the Charleston Conference. I believe you were also on the Hyde Park debate, which I didn't get to hear about.
I should say I lost to my colleague, Sarah Benson, who did a great job.
You lost that debate.
I did.
So one of you argued that copyright as we have it today is relevant, and the other one said not really. Which one were you?
I was defending the proposition that copyright law no longer fulfills its function.
Okay.
And of course, one of the problems with a debate format like that is if you're the affirmative, if you're defending the proposition, you're almost always forced into a pretty extreme position. And Sarah had the benefit of all the nuance in the world in her arguments. And, at the end of it, if I had been voting, I would have voted her way too.
I will have to go back and listen to the recording of that. So as we conclude, a couple of things. This interview will be edited by the technical wizard of the Charleston Conference, Don Lewis. And once he does that, it will become available. We will promote it widely to the Charleston audience. But Kevin, you and I should also get the ARL folks to listen to this and some others, because I think these are such important topics. And I think the Charleston Conference and Katina Strout, the founder, and Leah, the executive director, are to be complimented for always carving out a prime spot for legal issues at the conference. I don't know that many other generalist conferences do that. So again, thank you. We're so fortunate to have you. And I'll call on you again one day with some esoteric request which you will fulfill with clarity and style.
Well, thank you so much. I've enjoyed talking to you, and I did enjoy the opportunity to participate in the Charleston Conference.
Thank you.